Hi, everybody. Our special guest today is again law professor Joe Potuto. Thank you for being here today.
Thank you for asking me.
Sure. So we were just talking about how we feel like we haven't had enough time to digest all this because there's so much to read. So what I'll do, I guess I'll just go ahead and flash the state's appellate brief response on the screen, and we can hit the highlights. Does that sound okay?
Anything you want, Judy, is okay with me. You're in charge of the program.
Okay. Well, let me make sure I can find the correct PDF here. Okay. Yeah, and thank you for also being on Allison's live stream today. So you must be pretty exhausted.
No, I like to sit and talk. So talking and talking to other smart people never exhausts me. It's when I'm left to my own that I get tired fast.
Oh, okay. Well, that's great. And it's great that you still have such a strong voice after so many years of talking and lecturing. So I couldn't do it. Yeah. Okay. Well, let's get started. So this was filed actually, would you say a couple of weeks ago?
Yeah. What was the date?
Yeah. Let's see. Oh, September 4th. September 4th.
So just a few days ago, yeah.
Of the state. But everyone was so excited about Donna Adelson's guilty verdict that kind of went by the wayside.
Yeah.
Mm-hmm. Okay, so there's your table of contents. So the first topic addressed is the change of venue argument.
Yeah.
Okay, so let's scroll down to page 19. There's the citations.
I was interested in the name of the person who filed the brief because I thought I had heard somewhere that the daughter of the prior state's attorney in Tallahassee was handling the appeal.
Yes, and Jared Frost said something like how that was just typical because she was in charge of the department, but it looks like the actual attorney who did this was Charles Lee.
Yeah, that was the first thing that struck me, was the fact that it wasn't the person that I had at least thought I heard was going to be doing the brief. Well, I don't think the brief was all that tricky to do. So
Oh, do you need to get the phone? It's okay if you need to get your
No,
phone.
I know it. No, okay. I don't need to do it, but you wouldn't think that he would try twice.
Maybe it's urgent.
No, I know it's not urgent. I know exactly what it's about. So
okay.
Not urgent at all.
All right. So let's see. So they're talking about how Charlie's claim in his appellate brief about how the motion to change venue was done incorrectly is a bunch of bunk. And this sounds pretty credible to me. Sounds like a good argument.
Yeah. I thought they did it, I think, on two or three of the issues. They made two procedural arguments before they addressed the substance. And I don't know, obviously, I don't know Florida rules of criminal procedure well enough, but it seemed to me, I mean, I can't imagine that they would, make the procedural argument if there was no basis for making it. One of them was the change of venue motion was made orally and not in writing. And it seems to me, if Florida requires it be in writing, and the brief cited some cases, that it's a little extraordinary that the lawyers would not have filed it in writing. I thought I saw something that said possibly you can avoid that rule if the judge actually entertains the motion and decides it. And maybe that's what the defense is going on. But it didn't sound from this brief as though the defense even highlighted it in theirs, that it wasn't made in writing, but. And that always surprises me that, if there's a procedural rule, you would close your eyes and pretend it's not there.
Yeah, because they're saying it should have been written
Right.
with at least 2 affidavits and a
Right.
certificate.
Right. And, you recall in the, what would it have been where they did submit, it was Charlie's, wasn't it? Where they submitted 2 affidavits by people who didn't know anything. One of them was a lawyer who wasn't practicing there. I'm going on memory now, which is always dangerous. But
Well, I don't recall that for Charlie's, but definitely for Donna's. They had that very elderly
Right.
attorney who's just claiming, well, I've talked to lots of people, or I know lots of
Right.
people in the
That's what
criminal
it was.
justice system and the community here, and they all know about the case
Right.
or have some
That's what it
preconceived
was.
notion.
Yeah. So they learned enough from, and that's not the same lawyers, but at least they now are doing it in a procedurally correct fashion. And I assume most of the people in the chat know this, but you can have a world-class issue, and if you get the procedure messed up, you can lose the issue. And there are a lot of lawyers who are so hot to trot on the substantive issue that they don't do it in the procedurally mandated form, and you're in trouble. The easiest one to see is statutes of limitations. You have 2 years to bring a lawsuit. You can have a great claim, but if you don't bring that claim before court until 3 years out, it's never going to get heard. So this notion of not paying close attention to procedure, I think, is not very good lawyering.
Mm-hmm.
But
yeah, and remember, Rashbaum had his very first murder trial with Charlie. So this could have been why he could have missed this point of the requirement if it's true. So let's see.
That's why he should have joined another lawyer in the defense with him, which was another thing I never understood.
Mm-hmm.
Then
they had the money.
The second one, which is also procedural, surprised me even more, because Florida law says if you accept the jury and you don't reserve your claim, either object to it or accept it conditional on the fact that you think the jury panel or the jury pool was tainted and there should have been a change of venue. And he didn't do that. And that seems to me to be a bigger procedural hurdle to get over.
Yes. Okay. So in this part of the brief, they're talking about what Josh Tupin did. And again, he seems to, he has an office somewhere around Miami, but it seemed like he was really in New York City. So I guess he wasn't that familiar with criminal procedure in Florida.
Well, but you're not saying, I'm sure, that that's an excuse for this.
No, but I'm just pointing it out that perhaps he made the oral motion and didn't realize he had to put it in writing also.
The first part, but accepting the jury without, I don't know, I haven't done a survey, but I'm willing to bet that that's a requirement in every state. Mm-hmm. That if you're going to preserve that challenge to not getting a change of venue, that you have to, at the point at which you're asked, do you accept the jury, you've got to reserve the objection. I would be really surprised that that's something that's unique to Florida as a rule.
Yeah. So this is the part of the brief where they quote Charlie saying, yes, Your Honor, when he's asked if he accepts the jurors.
Right. And they had then peremptory challenges left, because one of the other issues that they raised was you have to show that you're out of peremptories if you're challenging whether the jury can be impartial and biased. And if you still have peremptories, you might be able to cure it by getting rid of the ones you think have the bias. Mm-hmm. Mm-hmm. Then they get to the substantive issue, which is whether the pretrial publicity meant Charlie couldn't get a fair trial in Leon County. what lawyers do usually is, even if you think you have a winning procedural argument, you go ahead and address the merits of the claim just in case the appellate court doesn't agree with you on the procedural argument. You want to have an argument there on the merits also. And so that's what this appellate lawyer did, went on to the merits.
Okay. This was interesting where they talked about the young man who said, we're effed because we're going to be here all day.
And never showed up the second day.
Yeah, but he didn't even show up again. So how did this prejudice his jury? Because maybe some people could have heard him, I guess, but.
Right. But wouldn't you think that what the jurors heard was, this is some guy who doesn't want to be here and he's going to say any damn thing to get out of it.
Yeah.
But this is the one, though, if you recall Donna's trial, where Judge Everett, in order to avoid that issue coming up again, that jurors might have been tainted by hearing somebody else say something that was indicated that the Charlie couldn't get a fair trial. In other words, if I say, gee, I think he's guilty, I'm not going to sit on the jury. But if I say, gee, I think he's guilty in a room full of other potential jurors, then the claim is that I've tainted all of them and we all need to be recused. Well, none of us can serve. That's the claim that's being made, because there's no claim that anybody who made these comments ended up on the jury. They were excused for cause.
Yeah.
So it's just the ones that are, that might have heard it, that the claim of taint runs to. And what Judge Everett did in Donna's trial, and I said this on one of these shows at one point, was he put extra bailiffs in the room where all the potential jurors were sitting, and he ordered them not to talk to each other. Bring something to read, there are magazines in the room, but you're not to talk. And that was in direct response to this claim in Charlie's appellate case.
Yeah, I think it was was it Joel who asked JC, the foreperson, was it awkward not being able to talk to these people while you guys were all sitting together? And she said, well, maybe a little bit, because you could tell some of the people wanted to talk, or for some people it's awkward not filling the silence, but they followed the rules.
Yeah. And so Donna, I don't think this will win in Charlie's case, but Donna's trial and Donna's appeal doesn't have this issue in it at all, because Judge Everett made sure a lawyer couldn't make this claim again in his court.
Yes. It was a kind of a good lesson, because people have to be cautioned and they have to be given something to do, because usually the natural inclination is to make small talk with people when you're just bored out of your mind sitting there.
Right. Yeah. And you can't, and at that point, you're not supposed to be looking at anything that might give you a hint about the trial you may be sitting on. So, your limit, the only thing you can do is read a magazine or a book, because anything else might create an issue that you didn't have when you walked in the morning. So,
yeah, like surfing the web.
That's right.
TikTok. Yeah. Okay. Well, what about this text message thing? I thought this is kind of interesting, because Charlie actually wanted to introduce 50 pages of about 400 text messages, which included sexually explicit text and him making racial slurs. That probably wouldn't have made him sound good anyway.
Well, you recall what the jury thought about Charlie in the whether it was email or text that were read to them in Donna's case, where he's talking about he wouldn't date even a
37-year-old Victoria's Secret model with 2 kids.
That's right. And there was some other comment that he made, so it wouldn't have gone over well. Now, Roshbaum offered to take out all those references and still allow the was it all text here in. I thought, gee, it's odd that if he read them, he wouldn't have, when he made the motion, say, and we would want to at the same time remove any of those references because they're too prejudicial. But this one, I have a little sympathy, not for the way it played out here, but a little sympathy for the argument. I'm the defendant, and you look at my emails, let's say, and within a 5-day period, you pull out 20 that I sent to my mother. And you say, this shows a really close relationship in the time frame before the murder. And I say, I want to show you the last 6 months, and you will see that I email her this much every day. And so it's deceptive to say there was so many in this period, it showed something nefarious going on, because that's my pattern. I have some sympathy for that claim. The problem was that wasn't quite the claim they made. They wanted to show that, and because the texts that they pulled were in the period where Garcia and Luis Rivera had driven to Tallahassee the first time in an attempt to kill Dan Markel. That was the June time.
Yes.
And what the defense wanted to do was pull text from that period to show there was nothing that suggested there was going to be a murder, that there was a plan for a murder, nothing that would indicate it. Now that's substantive. That's hearsay, because you're trying to put it in for the truth of the matter. That is, we didn't talk about those things before. And evidently, Rashbaum never defended it as permissible substantively. He just claimed it wasn't hearsay because it was not going for whether it was true or not, but Charlie's state of mind. And the state says it couldn't be state of mind because you want to be talking about something that happened in the past, and state of mind has to explain future behavior. Now, that's pretty technical. It's probably hard to follow, particularly for anybody who hasn't read the brief. But the claim was it wasn't going in for the truth of anything, and the judge says, yes, it was. I mean, why else would you put it in? You want to show that, these prove that you weren't trying to murder anybody in the June period, and therefore you can't look at the July period as being unusual or different. So I don't think this one has much chance either, but it's better than the change of venue point.
Yeah. Also, the state notes that ultimately he did just testify that none of the texts mentioned murder during his time period.
Right.
And Rashbaum didn't try to introduce text messages from July of 2014. And plus, they could have been using WhatsApp. It seems like
I know
they liked using WhatsApp because they thought it was more secure.
Yeah.
So.
Yeah. There were 1,000 reasons why it wouldn't have been very helpful. Even if the judge made a mistake and they should have been introduced, it would end up being harmless error. It couldn't have changed the result, the conviction at the end.
Mm-hmm. Okay. And now what's this about his statement about prior extortion?
Yeah.
He had a phone call where he discussed extortion with his mother.
Yeah. One phone call, as I understand it, right, Judy? It was one phone call?
It says a phone call.
And they let him testify to it. So he testified about telling her this. So again, I just don't think it's going anywhere.
Okay.
And that was on the bump, the extortion, as explaining the behavior after the bump.
Where he said it's not done this way or done that way.
Yeah, because he knows these things.
Yeah. Yeah. But I mean, that still makes him sound really shady. So just the fact that they didn't go to the police and they're all like talking amongst themselves, like, what's going on? Who is this guy? Maybe we should kill him.
Yeah. Yeah.
Yeah.
Which is why what the last argument is that Charlie makes is well, maybe none of these errors in itself, no one of them in itself was enough to require reversal, but the cumulative effect of all of them requires reversal. And essentially what the state says is if you have 0, 0, 0, 0, and you add them together, you still have 0. In other words, if none of them have any merit in themselves, you can't add them together and find that now you've got reversible error. And then the state's absolutely right about that.
Mm-hmm. Yeah. So this sounds like a winning argument to me, but we'll see how the judges rule.
Yeah, I think so. And I think, I mean, the defense had to do it, and they did their best, but it is a demonstration of how really error-free that trial was. I mean, I don't mean error-free in that there was no ruling that was wrong, but it was a pretty clean trial. And what the courts say is you're entitled to a fair trial, not a perfect one. And that's a good thing because we don't get perfect in anything in life. But I think that's what demonstrates. And I think the other thing it demonstrates is they're waiting until the appeals are done, because you and I, Judy, I agree with you completely. This is going to be not going to be reversed. It will be affirmed, the conviction. And then he may try to get the Florida Supreme Court to take a look at it. And I think it will be, the conviction will again be affirmed. And then they'll get to the argument that they do think has some merit, and that is the conflict of interest that Roshbaum had, and therefore the claim that there was ineffective assistance of counsel. That they have to do on what we usually say is habeas corpus. They have to do that after the direct appeals are gone. They come in horizontally and challenge the conviction in a different proceeding.
Mm-hmm. Yeah, I think they call it a motion for post-conviction relief.
Is that what they can call it? States call it different things. Florida may call it, because it's post-conviction.
Yes.
And what typically happens is, and I don't know Florida procedure, but I'm reasonably confident that this is the way it will go. You first make a petition for post-conviction relief in state court. And then if you're denied in state court, again, you can appeal. This can take forever. And you go up and you ask the appellate court to look at it, and then the Supreme Court to look at it. Everybody denies it. And then you go into a federal district court and file, we call it the petition for habeas corpus because that's what it was called historically. It's now a 2-2, I think it's 8-3 motion technically. But again, it's post-conviction, and you're going back to challenge the constitutionality now of the state conviction. And the constitutionality challenge is going to be a Sixth Amendment right to a fair trial, which includes having a lawyer who's reasonably competent and it does not have a conflict, can defend you zealously. And that's where I think they're putting all their, eggs. It's that basket. It's the post-conviction basket. Mm-hmm. So for those of you who are listening, Charlie's court adventures won't be over for a few years while he challenges all this.
Yeah. Well, for example, Sigfredo Garcia also filed the motion for post-conviction relief, just putting down his prior attorney, Sam Sanganhe, and it still hasn't been ruled on. Yeah. So how long has it been? He was convicted in 2019, and I'm not sure when he filed the motion. It could have been just about a year ago, perhaps.
Is that how long it took for his state? Because he'd have to start in state court. It's not inconceivable. Usually the state appeals can take 2 or 3 years before you're done. Okay.
Yeah, I'm not sure. I don't want to say anything wrong.
Yeah, I know. Well, you can't file the post-conviction until you can do it. Either you have to do your state appeals or if you've run out of time and no longer can file a state appeal. But that's a problem. Now we're back to procedure again. because if you didn't file an appeal in state court and give the state courts a chance to cure the error, if there was one, a chance to rule on it, and now you go into post-conviction relief, particularly federal post-conviction relief, they're going to say you have a procedural default because you should have raised this for the first time in state court. So again, the procedures can get you if you don't know what they are and you don't follow them properly. And there's more there, but it gets way too technical for anybody on this chat, or probably any other chat in the world, to want to know.
Well, I'm sure Deep Dive True Crime can cover it because he knows more about Florida criminal procedure than we do.
Well, I have a book on post conviction and habeas corpus, and it gets complicated. But the bottom line is there's not much of a chance. The ineffective assistance of counsel claim, if you can make it based on the conflict, I mean, if you really do have a solid case on the facts, is a pretty good one for post-conviction relief. But I don't know that it's going to be all that strong. But in any case, this appeal, I don't think is going anywhere.
Yeah. And I was just listening again to this comedic reenactment of a phone call that Charlie had with his last girlfriend, which I reenacted on my channel a while back. I think it was in July. And in that conversation, even Charlie seemed very pessimistic. He said that it was very, very unlikely that his appeal would succeed. And even if he did get a new trial, he would still have to have a trial in Tallahassee.
Right.
So
on the first part, that it would be unlikely it would succeed, he's getting that from his own lawyers. I mean, he's not making that up. That's what the lawyers are telling him about it. Yeah. I mean, there are very few, I don't know what the statistics are, but there are very few cases that are reversed on appeal. Because generally trial courts do a sufficiently good job to protect the record and to protect a defendant's interests. And so, it's not common that there are reversible errors in a trial that will lead to a reversal of the conviction. Because I'll stop there. It's not common. So.
Yes. From what I recall vaguely from one of the attorney's sons surviving the survivor, they said it's like a 5 to 8% chance, or 5 to 8% of cases do get reversed on appeal.
Yeah. And, some commentators look at that and say, the system is rigged, which I don't agree with, because I think the way to look at it is the trials are conducted in appropriate manner. Yes, there are errors made, but they're not of a magnitude that affected a defendant's right to a fair trial. And that number is a good number, because it means that by and large, the trials are done correctly. So there's nothing to reverse on appeal. So I think it's a consoling picture of how the system works.
Yeah. That things are done correctly from the start.
Unless you have a 32-year-old new lawyer who's a judge who's never done trials before.
Yeah, which happens sometimes. Well, I don't want to say too much. So, but let's see. I don't know if I should scroll slowly through this for people who really want to take a look at it. Then you can watch on replay and pause it. So this is talking about pretrial publicity.
And citing some cases that seem to be directly on point with this one, where the facts were worse in terms of pretrial publicity. And the court said, you could get a fair trial and the jury pool was not tainted.
Yeah, and even with Donna's case, it seems like they found lots of people who didn't know, because this happened so long ago.
And it's a transient, it's a university community. So students come and go. Government workers and are going to move in and out of a state government in Tallahassee. Faculty move to other places. So not only is it usually the case that a lot of people don't follow crime and are not following what goes on, but in Tallahassee that would be particularly true because of the number of people who weren't there over the whole time. The jury foreman said she'd lived in Tallahassee 4 or 5 years, but one of those years she was somewhere else and was well after when the murder happened.
Mm-hmm. Plus, some of them seemed so young. That young guy who's 24 years old, Evan, he said, I was 11 years old when it happened. And one of my teachers said something, but I didn't pay attention.
Yeah.
So
he's the one who's decided to change majors and go to law school.
Yeah. Do you think that's a good idea
from
engineering?
Was it in the chat that you made some comment he should think carefully about it?
Yes, probably. I think I said that. You know me, I'm all bitter and jaded about the legal profession.
Well, while you sit there with a successful career and a channel that's based on that, or at least derives from that successful career.
Yeah. Well, I think, this is totally going off tangent, but I think I was lucky because I came from a privileged background where my parents paid for everything. Then when I started my practice, I had a husband who could pay all the bills and support us while I was kind of struggling to build my law practice. So what happened to me is not really representative of what I've seen often does happen to some people who went to law school and have hundreds of thousands of dollars of student loans and struggle. So, everybody has their own story. So, just because one person looks successful or somebody went to 4th-tier law schools and still is raking in the big bucks, those are the types of examples that law schools like to tout when they're trying to sell their product. So.
Well, I guess I would say in defense of law schools, maybe 2 things. One, the state universities, the state law schools, while tuition is going up everywhere, they're not the ones that are, pushing students into heavy debt. The big national law schools with the national reputations, even with big, heavy debt, the likelihood is that you'll find a pretty good job and be able to, pay off the loans. The place where I think it's hardest is for students who do not get into a state law college and either can't get in or don't get into some of the major national law firms, law schools, and then move down to, you said 4th tier, whatever it is, move down to the law schools that do not have national reputations, that compete, that may not have even regional reputations, and also have very high tuition loads. And what I would say to people thinking about law school is, if that's where your GPA and your LSAT is driving you, then you really need to think hard and fast about how much passion you have for going into law or using a law degree for as a platform for some other career that's not directly a law career. And then I think it's still worth it if you really have the passion and you really want to do it. But if you're doing it for, without that strong interest, then I think for that group, you might want to think about whether there are other careers that you think would be as fulfilling and that wouldn't give you such a big debt load at the end of the process.
Mm-hmm. Yeah, this is just one example, but I did a post about 2 months ago about a young attorney who had been on one of my live stream shows a couple of years ago. He graduated from Pace Law School and also had a master's degree. Mm-hmm. So on his YouTube channel, it appeared that he had become homeless. So he was posting stuff about the food he was eating and how to sleep outdoors using a piece of cardboard or setting up a tent. And it was just very sad to see. So I don't know what happened to him because he hasn't been posting lately.
I don't know his case at all, but I find it a little odd, let's say, that if he was unable to find a straight law job, that with a BA, an MA, and a JD, he wouldn't have been able to leverage that background into some other kind of job. It's hard. They're government jobs. There are, administrative jobs in all kinds of, in firms and companies and even in school systems, where it seems to me that educational background would have gotten him, entree to a position. It wouldn't have been practicing law, but, and I shouldn't criticize him. I don't know. And that wasn't meant to be a criticism of him, because I don't know how he got to where he was, but it just seems to me to be, a little unusual, if that's the case, that not only couldn't get a law job, but he couldn't find anything else where he could leverage the degree.
Yeah. Well, he did pass the bar exam, I think New York or New Jersey. And I think he worked for a judge for less than a year. And when I spoke with him, he was a lecturer for a college class, maybe like teaching English or something. So of course, lecturers don't get paid much.
They don't.
Adjunct professors, that's
right.
Very low pay.
Right.
There could have been mental health issues. I'm not sure. So
it's still sad. You would hope that everybody who goes on, and even with a BA, but certainly with an advanced degree, then is able to find something that's compatible with the education that they like to do. So it's sad.
Yes. He said in one of his videos that he had $300,000 of debt because of college, grad school, plus law school.
All three, yeah.
Yeah. So that's why it's important to be selective as to what you go to school for and which school. Are you familiar with Brian Tamanaha or Paul Campos?
The name Paul Campos sounds familiar to me. The other name does not, but all that I'm getting is it sounds familiar, and without more, no.
Law professors. Yeah, Brian Tamanaha teaches at Washington University.
In St. Louis?
Yes. Okay. So way back when I first started my channel and I was focusing on the legal profession, he was one of my guests because he had written a really great book about law schools and how law schools operate and whether going to law school turns out to be worth it for most of the students. So I thought it was a great book, and he was encouraging his kids not to go to law school just because, I think the main reason is that it's so much more expensive to go now than it was back in his days, back in, say, 1982 or something, when he was able to pay for law school just by working during the summer.
Yeah. Of course, that's probably true of most graduate degrees too. They're a lot more expensive. And with a lot of graduate degrees, if you don't get a position teaching at a university, they don't translate very well either. Now, MBAs do, so I'm not talking about, certainly not everything, but a lot of them don't translate into many different careers other than teaching. But, that says two things. One, again, you may find something that isn't in the field you specifically trained to do. That doesn't mean that the degree and the education wasn't helpful in any event. And two, we've gone a long way from, the idea of a liberal arts education where it has value in and of itself. You read the great books, you learn analytical thinking. If we're talking about law school, you learn it elevates and expands your, your view of the world. It gives you another perspective. It, teaches you how different cultures operate and all that, and whether that, is a value in itself. And I think most of us would agree it is. The issue is whether in these days you can afford to do it. And then find, a career where you can pay for the money that the expenses you incurred in order to get that, expanded, liberal view of the world, and then be able to make back, or, enough to live on.
Yes. And speaking of that, I wanted to mention the economics of having a law degree versus what the starting pay could be. And last year, I looked up how much prosecutors get paid in Florida, and it was very dismal. It was something like maybe upper 50s or 60K starting pay.
Yeah.
And of course, through the years with more experience, they can make more and more, but that's kind of a low salary.
Yeah. Well, that's government. I mean, public defenders don't make any more than that. They probably make even less at the start. And that's government, government employment generally. It's also teaching, university teaching. The people's educational background, their experience, their abilities, if they went into the private sector, could probably make a lot more money, but there's a trade-off in terms of the satisfaction you might get for being in a public defender's office or in a prosecutor's office or, in a legal aid office or in a government position, public service generally, as compared to the private sector. And, we all make those, hopefully many of us have the opportunity to make those choices about whether you'd be willing to trade the higher salary for the satisfaction in the job you're doing. I mean, even lawyers who go onto the bench, a lot of them had very successful, very lucrative careers, and then they're judges. Look at what judges' salaries are. It's nothing like what a partner at even a medium-sized law firm brings in.
Mm-hmm. That's right. That's why we're grateful that there are people like Georgia Kappelman and Sarah Catherine Dugan who decided not to go into private practice. I'm sure they could be very successful doing criminal defense, but they've stuck with the prosecution.
Right. And one thing that prosecution and actually defender's office gives you is a lot of trial experience. And for people who enjoy doing trials, there's nowhere else you can go and be able to do trials, regularly and as frequently as you can in those offices. It just isn't available. You saw that Sarah Catherine Dugan has applied for a judgeship, didn't you?
Yes, I heard about that. So I'm sure she'd make a great judge, but we kind of want her to stick it out if there is still going to be prosecution.
Yes, I agree with you. It'd be nice for her to, see it the whole way.
Yeah. What do you think of the chances of Harvey getting charged with anything?
I don't know. Even this trial had a little more, about his maybe involvement. I think it's a kind of sit around the kitchen table, have a cup of coffee, thought about it. It's very hard to believe that in a marriage as close as his was with Donna, and in addition with how focused he was on where every penny went, and there's a lot in the record about that, that person who was really careful and focused on money coming in, and who was in a very close marriage with his wife, wouldn't have known what was going on. For me, it's just almost impossible to believe that he didn't know in advance. And I think the evidence in the record afterward makes it even less likely that he didn't know from the bump on that there were problems. And that's where more money was coming out of the firm to pay Magbanua. He went with Donna to drop off the money the night of the murder. He's in that, that sort of the two heads are at the table with Charlie out at a place in that, where was it, by the pool or restaurant where nobody could get near them. Yeah.
Monty.
And so, it just seems to me that the after is even less possible to believe. So maybe they would have enough to go after him for accessory after the fact. And we don't know. Maybe they think there's enough they have in the record that would allow them to go after him for conspiracy. But I do think that if and when they indict Wendy, that they will either indict Harvey at the same time or they'll never indict Harvey. Because if they indict Wendy, even though I was more than willing to believe a few hours ago that they indicted her today because that troll information came across Allison's screen, it would take, from indictment to trial on Wendy is we're looking at probably a year again. And then they would have to have the trial. And then same thing, if then they wanted to go after Harvey, number one, they wouldn't have Wendy anymore to testify against him. And two, it's so many years out that it's hard for me to believe. It's not equally, but it's also hard for me to believe that they would do Harvey first and then Wendy, because it seems to me we're getting a long way out to go after Wendy. So my best guess is if it's going to be Harvey, it will be when they try Wendy. And unless they have more information that we haven't seen, it won't be for murder one. At least it won't be for murder one. It would be for something else.
Yeah, I've mentioned this before, but let's see. I think it was probably around December of 2022, perhaps, when STS had that special Ruth Markel book signing in an event down in Florida. And there was a former Adelson employee who wasn't shown on camera, but she stood up and talked about how she had worked on Dan Markel's teeth and how she knew that Donna and Harvey were both so mad about Wendy's divorce from him and so mad at Dan Markel. And she ultimately got fired because she didn't get paid. So she raised the issue with Donna and said, hey, I haven't gotten paid yet. And so Donna got mad at her and said, well, don't you know how stressed out we are right now? We're busy, or something to that effect, where Donna turned the tables on the poor employee and fired her. So I spoke with this person. I'm not going to give out her name, but she did say that Harvey was totally into the money. He knew where every dime went. He wasn't some doddering old senile person. He's like a shrewd businessman who watched the pennies. So there's no way they could have just had $138K taken from the family's safe and writing out checks to Kate without him knowing.
Exactly.
Exactly. Yeah.
I agree with you.
So, yeah. Let me continue scrolling through this. I don't know how many people really want to go back and look at it here, though. Yeah. So how are you feeling after the trial, though? Do you feel kind of like it's like a letdown now? Like, what are we going to do with our lives?
Yeah, that 2 weeks, it was very busy because except for the time when I had to duck out because I had a funeral to attend, I did it, the whole time. And that meant that everything that I had to do during the day, I couldn't do at night because a lot of those things, you can only make phone calls, you can only run errands during the day, really piled up. But it was also, I found it a lot of fun, and I would have tried to watch all the trial anyway. I might have watched a little of it in tape replay at night rather than live. So it is, I've got a lot more time now during the day than I had, and I do miss it. And I really enjoyed interacting with the people who were in the chat during it because they asked a lot of really interesting questions, and they were really engaged. And it was, it was fun to try to explain some of what was going on while it was going on. So I would like to do it again. I think I mentioned on Allison's show that I think that I have decided to try a channel and see how that goes. And ultimately, it would be fun to do trials. But you tell me how your experience was. I felt so bad for you that when the verdict came in, I mean, I had this picture of you outside the building walking around and not being able to get in. That was so sad.
It's okay. I think I got one mosquito bite. I was kind of like slapping around trying to kill mosquitoes and stuff. And it was a little bit warm and humid too. So I got my exercise walking around the whole building and putzing around outside the building, thinking like, well, maybe somebody will come out and I can go in.
Pound on the door?
No, there's nobody. There was nobody there.
Wasn't there someone on the inside you could have phoned to say, come open the door
Well,
for me?
I guess I could have texted Patty or somebody, but after a while I was like, well, I'm resigned here. It's okay. I felt safe standing out there by myself with all the traffic going by and watching live on Deep Dive True Crime.
But you traveled all the way down there.
It's okay.
And you missed the verdict. I just thought that was
okay.
awful.
Yeah. Well, part of it was just because I was exhausted. So once the court proceedings ended, then I was like, oh, great. I'm going to go back to the hotel and get some snack to eat and, take a shower and just relax in the hotel and stuff. I really didn't think it was going to happen that quickly. But then finally, I think it was my roommate, Patty, who called me and she was like, Judy, they got a verdict. Get down here. I was like, oh, okay. Well, I got to put on some regular clothes again. So, yeah, but it was okay. I mean, it was just great being in Tallahassee and the people there were so friendly and nice. It's like Southern hospitality to the extreme. For example, when we would go places, we could just ask a stranger for help because we couldn't find where the restaurants were. And there was a police officer who was riding on his bicycle and saw Patty and me just stopped in her car because we were totally lost. And he asked us, can I help you? And I was like, oh yeah, we're looking for this restaurant and stuff. So yeah, everybody was just so kind. It was fun being there, about as fun as it can be when you're there for a murder case.
Will you go back for Wendy's?
Yes, definitely. So, I mean, I don't know what the work situation and family situation will be, but I hope to be there. Mm-hmm. Yeah. Any chance you would go?
I don't know. You're right. I'd have to see when and what. This time I couldn't because I had stuff right up until the day, almost the day of and right after, and there just wasn't any way to skip. And of course, it was a movable date, as you know. It kept being moved back a couple of weeks, so I just couldn't do it. I'd like to, but I also liked a lot watching and being able to talk about it, and I couldn't do both.
That's what's frustrating because that's what James, mentor lawyer, was saying, that he preferred to actually be there in person, but then he's left with that dilemma of his YouTube channel. Who's going to be there? Who's going to be that face talking on the camera live? So were you on STS every single day of the trial?
Yeah, right. Started. I couldn't do voir dire. Now I'm forgetting why. I had a conflict with both until the afternoon of the second day of voir dire. I had a conflict. And I missed a little of George's opening live for the same reason. But then I was, except for that 4-hour block when I went down to a funeral mass, I was there for the whole time. And I wouldn't have wanted to miss anything. I hear Joel sometimes say on SDS that, he gets bored with some of the details. And even when Corbett was testifying, when they go into all the, this is where the
cell phone
towers are, and this, that he just, his mind starts to wander. For me, all of that is fascinating, in part because I don't know it, and it's just fascinating for me to listen to somebody who talks about something and I don't know it, and I feel I'm learning something, which is always great. And it's just always fun for me to hear someone who knows something and obviously likes what he's doing so much. And then the little legal arguments and things I find really fascinating. And the testimony and the way the prosecutors or the defense asks questions, and all of it is interesting to me. For me, it's like watching a good play on Broadway or a good movie. I mean, it's just, and there was one point where I was telling someone I had said, if Donna actually gets on the stand, we all need to have popcorn, because that's how I felt it was going to be. And I don't want to minimize. I mean, it's a murder and it's terrible, and there's such an impact on so many people, and it's just horrible. But there's a part of me that also has that feeling. So yes, I watched it all, and it was not it was not any kind of a burden, except then I had so many things to catch up on afterwards, and try to fill in and try to get done. But I liked it. I liked it a lot.
Mm-hmm. Well, unfortunately, since I was so busy with my own trial and then going to Tallahassee, I didn't get to watch much of your commentary during the trial. So were there any real poignant or funny moments or interesting moments while you were doing the live stream?
I don't know that I would pick out anything in particular. What parts of the trial were interesting. Mm-hmm. The one thing I will say, I was really, and I said this earlier in response to your question, or maybe it was earlier today when Allison asked, some of what the defense lawyers really did really perplexed me. The testimony of the second lawyer, the family lawyer who testified as an expert, I could not understand why they put her on the stand, what they expected her to do. I could not understand, as a lawyer who has seen trials and worked with witnesses, that she couldn't figure out how to do better on the stand. I thought she was just a terrible witness. I could not understand the claim they were making that the divorce was amicable. Linda Bailey, thank you, Julie Nielsen. How they thought anybody was going to buy that in the face of the emails and everything else. But what I couldn't understand, in addition to all of that, was assuming that the jury would agree that, that divorce and the child custody thing was amicable, and now it's over because the court has ruled, how they expected anybody to say, well, good, that means they couldn't have murdered him, as compared to they tried to get it done in court. And when their opportunity to get the kids moved to Miami through the judicial process ended, then they went on to the new plan. So I didn't understand that at all. And I shared those thoughts a fair amount. And then there was one place in the trial where Jackie Fulford said, wait a minute, something like, wait a minute, I have lost my train of thought. Yeah. And to my regret, I said, I hadn't noticed she had a train of thought.
That was harsh.
That was snarky. But it was out before I could catch it. I try not to do that, but every once in a while. So that, I don't know, it was a high point or a low point, but that's the point I remember clearly in my comments.
Mm-hmm. Yeah. Whereas during Charlie's trial, I remember everyone was talking about how Carl Steinbeck started laughing during Rashbaum's opening statement. but when I went back, this was on STS. When I went back and finally saw that little snippet, I saw that Joel or his wife had flashed on the screen somebody's comment that said, Chucky's about ready to ask for a refund right about now. So I think that was why Carl was like laughing. But anyway, everybody was talking about it because, he's usually very reserved, and you don't think of him as someone that starts busts out laughing. But so that was kind of memorable in terms of YouTube coverage of Charlie's trial. Mm-hmm. But did the other commentators feel the same way as you toward Fulford or the witnesses?
Of course, I didn't watch. I couldn't watch any of the rest of it live, and I didn't watch a lot of, the programs at night. But from what I gather from the things that I have heard, that I've heard on some of the programs when I just, drop in for a few minutes? I think the answer is yes. Everybody felt pretty much the same way, as did the 3 jurors who were interviewed. They tried to be very polite and very gracious also, but they had the same reaction to the defense lawyers, certainly the same reaction to Linda Bailey. I thought for another thing I thought was just strange was running the tape of Donna and the informer, Bernhardt, sitting there, and they did almost an hour of it, as it turned out. And I didn't see how they thought it was going to help them at all. And at least one, maybe 2 of the jurors said the same thing. So a lot of my comments went to just being curious about what the plan was they had. And I finally decided that maybe part of the problem that they had was they had expected to keep out the information about the extortion, Charlie's story about why he was giving money to Magbanua, and why there was stapled money that Rivera got, and all of that. I finally decided that they had not anticipated that Georgia was going to be able to get in that extortion theory through her presentation of emails and texts that Donna sent that showed that Donna, it was adoptive admission that Donna had embraced that story. And my best guess for what looked like disorganization, in the defense might have been that since they didn't expect that to happen, they were caught a little off guard and couldn't get their defense back on a track. And you heard Georgia at the end in the closing say they had to pick a lane. Either Charlie was being extorted and this was a terrible thing and all of that, or, that he was a bad person and he had actually, been involved in the murder. And what they did was both. And Georgia said at the end, you need to pick a lane. And that's true. They had to say one or the other. You couldn't give both to the jury and have the jury decide, that your defense is effective. And so my best guess was that's what happened to them. And from there on out, they just couldn't take a breath, step back, and figure out what way they were going to go. And that enhanced what I think was going to be disorganization anyway.
Mm-hmm. What about Zelman? Like, people haven't harped on him as much as Fulford, but what did you think of him?
Well, I thought he engaged, he had a better relationship with the jury than she did. He just wasn't quirky in the way she was. He didn't call Daniel Rashbaum Danny, which really bothered me a lot. So he didn't do any of those kinds of things. But I don't know that his cross-examinations did a whole lot more to help the defense case. So I thought he was better. And I think both of them clearly were limited by how bad that case was. Whether he could have done better, I don't know. I don't know. I guess my major criticism is why it appeared to me, and I can only speak from what I saw, why they didn't do more before they got to court working out what evidence they were using and whether it was going to be helpful or not. And if they did, then I think they made woefully bad judgment calls. And if they didn't, I don't understand it. I said to somebody, I don't know if I said it while I was doing the commentary, that I thought the defense witnesses at best didn't help the defense case. And at worst, they really helped the prosecution case. I thought Linda Bailey helped the prosecution.
That's what I was going to say. Yeah. So those jurors who spoke out, they were so annoyed or disgusted with her, and they were also turned off by Donna's rich friends.
Yeah. I mean, that doesn't go to guilt or innocence, except that when they were turned off by the rich friends, they didn't believe them. And Linda Bailey who kept saying it was amicable, only accentuated the evidence that the jury saw that it wasn't amicable. And you know this, jury. You do jury trials. You can't lose your credibility with the jury and then expect to prevail. I mean, if they don't believe you as the lawyer when you're making an argument, then they're not likely to believe the information you're providing in the argument, or at least it's a much bigger hill to climb when that happens. Mm-hmm. And the juror on STS, the one that Joel called, what do you call him?
Sprinkler man? Mitchell.
Yeah, right. Who said when Jackie in closing got up and said, this witness said this, and he said to himself, no, he didn't. And this witness said that, and no, she didn't. I mean, that you can't win doing that, because not only do you lose credibility, but you focus on and underscore exactly the evidence that you're trying to get the jury to discount, because you're highlighting it, and then you're telling them something about it they don't believe. And the end result is that you're getting exactly the wrong result. So,
well, I mean, what about that very young forensic analyst who came out from Oregon or something?
Oh, the other one.
Kelsey Quay.
Yeah.
Yeah.
Well, she did the same thing. She ended up saying she agreed that essentially the Corbett was correct. She focused on information that wasn't really pertinent. She ended up saying that what she could give them was more precise. And when she was asked the question, how does it help the defense? She get that long pause. And then she said, well, I think it always helps to be more precise. She didn't say anything was wrong with it. Mm-hmm. Yeah, I don't understand it. I don't.
Yeah, and to think they spent so much money flying her out, and it was bizarre. I've never seen an expert witness act like that.
Well, Linda Bailey was an expert witness, and she sounded as though she was a fact witness for the defense. I mean, expert witnesses, no matter what they think, they should sound neutral, and they should convey information in a neutral manner, because once they start sounding as though they're aligned with one side, they don't sound like an objective expert anymore. Mm-hmm. Yeah, did they have another expert? But those two were not helpful. One was not helpful. The other, I think, was helpful to the wrong side.
Mm-hmm. Yeah, I think those were the only expert witnesses. Yeah. So thank you, Not Today, and thank you, Bichon Mama, for your support here. So do you have time to answer a few questions?
Sure. I don't know that I'll be able to answer them, or at least answer them well, but I have the time, The only thing I have in front of me is Italian homework, and we're doing the subjunctive, and I don't like that tense. So anything that keeps me away from it, I'm happy with.
Oh, so how are you taking your Italian lessons?
The ones I'm doing now are over Zoom with a group who are actually local, but we do it over Zoom anyway. We meet once a week to do that.
Oh, that's great. And who's your teacher?
She's a local instructor in several languages, and she runs an institute in one town away from me. So she teaches languages all day long. She's a very good instructor. She was born in Italy, so she knows that culture pretty well, and she's terrific on grammar. So,
that's great. That's great. Well, you have to kind of immerse yourself, right? So, do you plan on going back to Italy next year?
I've done 3 of 45 days with, mornings learning the language and afternoons and weekends, traveling and things. The first 2 were helpful. The third one, I didn't think the school was very good. And if I'm going to take a class and pay money for the class, I want you to push me and give me homework, and I want to be a little miserable about it. I do not want it to be a kind of, we go along to get along experience. So I will be doing Sorrento in the early spring. And then next fall sometime, I think I will be doing Trieste. And I'll go over to Venice for a couple of days while I'm there. So,
wow. Sounds like a great way to live now that
yes, it is.
teaching
It
full.
is. But it's
Yeah.
the same thing. I leave here and, the work here, the interesting thing about work is it doesn't stop when you do. It keeps
Yes.
piling up. So, then I come back to, just a room full of things that have to be done because some things you just can't do while you're away, not even with a computer and a phone and everything else. So.
Yeah. Yeah. Well, one question, I can't seem to find it because we got so many comments. Somebody wanted to know, could Donna use the same appellate attorney as Charles?
No, I don't think so. She's going to have to find a different appellate attorney.
Okay.
For the same thing, he's privy to confidential information from Charlie. Not as much as a trial lawyer would be, but he's still privy to confidential information from Charlie. He can't make conflicting cases on appeal. Charlie's not guilty because Donna's not guilty because Charlie lied to me. He's not going to be able to do it. So no, he won't be able to do the appeal.
Mm-hmm. Okay, thank you. So this is interesting. Heard a rumor Wendy may have met up with Sigfredo at the beach after Yintra left. I could see Wendy using her looks to get him to finalize the job. How do you feel about this? I don't think so. I don't think it would have happened the day at the beach, though, because, Sigfredo was mad about Katie being with the dentist. So why would Sigfredo want to go over there where Charlie also was and Katie was there too to meet up with Wendy? And Lewis, first he said he thought that Sigfredo did know Wendy, but then he kind of backed off on that and said, well, I'm not really sure. I don't know for sure if Sigfredo knew or talked to Wendy. So I have no idea. I mean, it could have been that once again, they were in these, what do you call it, like train cars where only one person communicated with the next person who then communicated to the next person. So I'm not 100% sure whether Sigfredo did talk to Wendy or not, but he did supposedly point at somebody and said, there's Wendy. That's the lady we're doing this job for. So that makes me think that he did know who Wendy was. So let's see here. Oh, okay. So that was Melissa's question there. If you guys have any questions, feel free to drop it in the chat now before we end, because it's kind of too time consuming to scroll through everything looking for questions. So yeah. What evidence do you think could show Wendy solicited murder?
I think some of the best evidence is the Halloween night call, where the Halloween night where Charlie first broaches Magbanua about, somebody who could hurt somebody, and she says yes, and then he sends Wendy a picture of him with Magbanua, and that's the same day, isn't it, where she decides not to go ahead with the house purchase in Tallahassee. I think that's pretty suspicious. In this trial, there were I think they were texts. It was when Sigfredo and Rivera went to Tallahassee the first time in June. And then, of course, they didn't do the murder in June. And I believe it's a text between Charlie and Magbanua that sort of says, "What's up?" There's also a text from Wendy to Charlie saying, "What's up?" essentially. I don't have quite the language. That seems to me to be also pretty suspicious. I think the fact that Donna had in her planner the car and the license that Dan was using could only have gotten that from, or probably only could have gotten that from Wendy. I think that points to Wendy's conduct before. I think her being, according to Jeff, being so nervous and she had the upset stomach, and that was around the time of the first attempt to kill Dan, seems, pretty suspicious. None of it in itself shows soliciting murder or murder, but all of it added together, I think, can get you there, particularly if the prosecution is able to show the jury that Wendy is the kind of person who could do it. Once they believe that Wendy could, they will look at the evidence that shows that she did in a light favorable to the prosecution. But they've got to get to the point where the jury thinks this is somebody who could have done it. And that's why motive is important. If you got a lot of motive about her wanting to be in Miami, she changes the evidence about the names of the boys. The change was already being used at the time of her father's birthday party, which is before the murder. All the information about what they're doing as a birthday gift for the father, when you have Rob saying there was no birthday gift, he didn't like birthday gifts, what he wanted was for us to all be together, there was no surprise party, also goes to her information before. Now, with the particular question, did she solicit? You don't have to be the one. If Judy and I want somebody to go out and rob a bank for us, we don't both have to go together hand in hand to ask that person, will you rob the bank? As long as we're agreed together that we're going to do it, she can actually ask the person. That doesn't mean that I haven't solicited too. For a crime, it isn't that you can only have one person commit the crime. There can be several of us who committed the crime. So if there's enough evidence that Wendy knew and participated and did some acts in advance, particularly, and to solicitation, if you read that evidence the right way, the way towards guilt, then the fact that she gets that message from Charlie on Halloween with the picture of him in Magbanua, and that I think that was the day that she agreed not to buy the house, would show you that she solicited.
Yes. Okay. Plus the texting Dan asking what he was going to be in town between the 14th and the 18th because she wanted to take the kids someplace on Wednesday.
That's a big one. You're right.
The schedule was already set anyway, and she sent the text when she was located around her parents' condo.
That's a really big one. You're
that's
exactly
just
right.
very, very suspicious. So.
And she also, wasn't it the day of the murder? Was it the day of the murder where she sends that text to Charlie, so sweet?
Yeah, that's so sweet. Or this is so sweet. I think it was that's so sweet. Yeah. Let's see. What's your best guess as to how much they've spent on attorney's fees? My guess is probably at least $3 million.
Well, think about it now. You've got Rashbaum on Charlie, Rashbaum on Donna. Then we had the two lawyers that were there for only a few weeks. Yeah. On Donna. Now you have these two on Donna. You had the
Marisol Tascalso.
That's right. And you also have the lawyer who did the jury voir dire for Charlie.
Yeah. Dupin and his whole group.
Now I'm assuming that Wendy's paying for her own lawyer to go back and forth to these trials with her. But that's a lot of lawyers.
Plus appellate lawyers. There was Kate Myers also with Rashbaum.
Yeah. And I don't know about Marisol's, but I'm assuming that Rashbaum at least is paid more than $500 an hour. Now, I mean, he may have done it on a, flat fee for the trial. We don't know how he was paid. I wouldn't even want to try to guess, but it's a lot of money.
Mm-hmm. Yeah, and it seemed like Rashbaum was totally focused on Charlie and then Donna as his client. So he probably gave up a lot of potential work to focus on them. And Donna was calling him like crazy. That's why they had that mother-son relationship.
Yeah.
You know, she expects people to be at her beck and call.
And these lawyers, they did more hearings and more motions and more redoing of motions. So I wouldn't even want to try to figure, the first thing you would need to know is whether they're being paid by the hour or it was to take the defense. If it's by the hour, I don't know how I would calculate it, because it appears as though what we see in terms of the public stuff, they were spending a lot of hours, and that doesn't count the behind the scene thing. So yeah, I would only say a lot of money and then leave it at that. More money than I have by far. I will say that.
Okay. So why haven't the feds not stepped in with a RICO charge since the Adelsons used their business for murder? Not a fan of the subjunctive or imperfect tenses either. Thank you.
I can do imperfect, let me say. I just don't know when I'm supposed to use it, but I know what the endings are for imperfect. Subjunctive is just, it's a different story. RICO charges are not done. RICO was I think we all know this. RICO was initially designed to go after organized crime, and in particular the mafia. And in fact, Blakely, trying to remember what his first name was. Is it Charles? Anyway, Blakely was a law professor at Cornell, and he helped the congressional committee that drafted that statute. And the why it's RICO, the racketeering influenced, what is the C? Criminal Organizations Act. He went out of his way to try to find an acronym that would be Italian, because he thought that was just really funny. And he used to tell his law classes at Cornell that all the time, Robert Blakely. So it was designed for the mafia. It was designed for organized crime. It is expanded, into a lot of different areas. But in the first, so that's the description of RICO. Criminal law is basically state-based law, and that's where I think it should be. I don't think we should be looking at federal prosecutions unless there's a real federal connection. It's the killing of a congressperson. It's transporting drugs across state lines for sale and distribution of the drugs. But otherwise, I think those prosecutions should stay at the state level. And RICO, I guess even more strongly about that we shouldn't be, at least my view is, it's not appropriate to be pushing a statute that was designed for other purposes into different areas just because we think we can squeeze it in and make it fit. For me, that's not an appropriate use of the law in general and the criminal law in particular.
Okay, thank you. Okay, so I think you've explained this before, but what if Charlie had just said he wanted Dan harmed?
And never. Yeah, the problem with that, there's probably a tiny little room where that could be done. But the problem with it is you can't say to someone, go out and hurt somebody badly, but don't kill them. And then if the person dies, say, well, I told him not to kill him. You put the activity in motion, you sent the actor out there, and you're responsible for consequences that maybe you didn't intend, but were foreseeable by what you set in motion. And that seems to me that's got to be the right way to do it. Otherwise, anybody who wants to solicit somebody to commit murder would say, I want you to shoot him, but only in the upper shoulder. Don't get him in the jugular or the heart. We don't cut it that closely. And in fact, for murder, you do not have to intend to kill in any event. You have to intend to kill or inflict grievous bodily injury. So to the extent that's the definition, depending on how that jurisdiction treats grievous bodily injury, you really haven't gotten out from under it by saying harm, don't kill.
Mm-hmm. Okay. And this is Gary. He was my guest recently on a live stream show. He's a former corporate attorney who is now president of a chain of restaurants in Connecticut. So, Gary, thanks for your statement that Linda Bailey's office is next to Mentor Lawyers. He ran into her in the parking lot. They talked about her being attacked online by people all over the world.
Yeah, I mean,
well, that's what she put herself out for.
Yeah,
So.
she agreed to be an expert witness. That's true. But I also don't think, I don't like the online, the sort of attacks and the, if attack means ridiculing her, that's one thing. But if attack means threatening her or really saying viable things or not, I think, and I think this last week with Charlie Kirk's killing just underscores that we should be better than that. And, and I do think that all these, all the social media stuff, it's too easy to be cruel in ways that you would never be face to face with someone. It's just too easy, and it's not, I don't think it's a good direction for us. When we were doing law school classes by Zoom, it was so clear how much easier it was for students in Zoom when they're not sitting with the other students in the class, and they're not going to walk out of the classroom with them or see them at lunch, to sort of phrase things or say things in ways that they wouldn't do in a live classroom. And there had to be rules created for Zoom classes about what the decorum should be. And so I'm sorry for lecturing, but this is an area that really bothers me, that, we're just not so many, let me say it differently. There are people on social media and other things that are unduly unkind. And I can say that about myself because I'm critical, clearly, of how they did the defense, but I hope I'm staying on the side of criticizing the way they handled it or didn't handle it, what it appears to me they prepared for and didn't prepare for, without getting into sort of ad hominem attacks on them as people. It just really bothers me that we're moving in that direction, or seem to be moving in that direction. But I think it's now saying at lecture ended, it's fair game to say that as a lawyer, saying $80,000 is not much money is something that she should have realized was not going to play well with the jury or the gallery in terms of making an effective argument. So.
Mm-hmm. Yeah, to me, it seemed like she's been good friends with Kristen Adamson since law school days, and she probably thought this is a great way to make some extra money getting involved in this big case.
Yeah, and I heard people say, I think John Singer on SDS said this, that what bothered him was the first lawyer who actually represented Wendy. And so she was going to be called. She had no choice in the matter. But Linda Bailey affirmatively decided to go in as an expert, and that does put her in a different, I think, in a different category when one is thinking about whether to criticize. But I don't think she did. I said that. I don't think she did a very good job. And I don't know anyone who thinks she did a very good job. Yeah. Or even an adequate job. And so if those are the kinds of attacks she's getting online, then Judy, you're exactly right. She put herself in the bullseye. Well, let me use a different metaphor. She put herself, in the game by agreeing to testify and then testifying in the way she did. And then she should be able to handle the criticism that comes her way because of it. Mm-hmm. Just as people in the chat, you should be able to criticize me. I wouldn't want you to tell me that, something ad hominem, but if you want to tell me my comments are ridiculous and I talk too long or who knows what, you should feel free. That's valid criticism. Yeah.
But although you are a professor emeritus, you distinguished chair, etc., former editor of the entire law review at Rutgers Law School.
Yeah, that doesn't give, so what? That and what, $3 will give me a cup of coffee?
Okay. Well, how about this? Do you think Charlie's appeal will postpone Harvey and Wendy's arrest? I don't think so.
I don't either.
It's taken way too long. If they're going to arrest Wendy, you would think it would be within the next couple of months
That's what
or
I
this
think.
year.
Yeah, that's what I think. Yes. I don't see that they're going to have anything more now that they don't have already. And I think they've got enough to go. And so I don't see any reason to wait. As I understand it, the grand jury in Leon County is meeting this week. It doesn't sound as though it sits all the time. In states that have grand juries, not all states have grand juries. Some of them go through what's called a prosecutorial information. So the prosecutor just brings charges, and then there's a preliminary hearing to make sure that there's probable cause as a check on the prosecutor. The grand and whenever a case comes in, they just bring it. Some of them have a grand jury that meets 1 day a week. Some of them have grand juries that meet 1 week a month. He has a grand jury maybe come in and sit for 1 week or 2 weeks, and then it's not there anymore. It's going to sit right now, as I understand it. But somebody said that Georgia and the other people in the office were getting 4 or 5 days off to just chill and not do anything.
Yeah.
I assume they will have to go, I would, if I were they, go back to the office. And even though I obviously know what the evidence is, still everybody on the team, including Jack Campbell, sit down again and review everything and make sure that they think they've got enough and this is the right time to go, that they don't feel there should be something else they look at first. They really think they're ready. And then they'll have to wait for the next time the grand jury, convenes. So that could be a month, that could be 2 months. I would hope it would be sooner rather than later.
Mm-hmm. Well, were you on that show when Dave Ehrenberg and Jared Ross were there?
I've been on with both, but
right after the verdict, I thought you were on it.
Tell me what something Dave said?
Yes.
Yeah.
So Dave was on and he seemed so excited and thrilled after the guilty verdict. And he seemed very optimistic that Wendy is going to get arrested. Mm-hmm. And he said that it would probably take at least a month or two.
Okay. I don't know. I was on with him when it was the night after Luis Rivera testified and said, Wendy. And Dave said that night, that's it, they're going to prosecute her. And I said, well, he doesn't have, we don't know that he has any firsthand information that it was Wendy. Right. Before he said the lady, what difference does it make? And Dave said, well, the prosecutor now has all over the paper that one of the killers said Wendy was involved. He can't not go forward. And I said, and he said, of course, I think there's enough evidence. And I said, well, I'll defer to you on the political administrative judgment that Campbell would make. And if you think that they have enough evidence and that comment from Rivera makes it difficult for a prosecutor, the chief prosecutor, to say not to indict, then, I'm going to believe you. But that was his view, that Luis Rivera's comment, in addition to the evidence they had, meant that they were going to have to go forward. And he was speaking as a former, head of a county office.
Mm-hmm. Okay. Thank you. Why do you think Katie is still holding back? I think her memory is probably shot because she was taking Xanny bars all the time. Charlie was giving her Xanax prescriptions and she was smoking weed and she had COVID twice. I guess her attorney used that as an excuse as to why she was fuzzy on the stand at her trial. So I think Katie's memory is just poor. And she's just a crappy person. Yeah. So she's still trying to make herself look sort of good and still acting like Charlie didn't promise her more money.
Yeah.
Or
and
favors.
Plus, at this point, I don't know that it helps anybody if she provides more or different information. It's just going to make her sound more like all she does is lie to suit the occasion. Yeah. So I don't even know that it would help. And if you look at Jeff, I thought Jeff was a very good witness, but I don't think he was as strong as last time. He didn't provide the same information with, for example, with regard to Wendy saying, "Can I tell you a secret? My brother said he had looked into hiring a hitman." Every other time he said 15, or maybe it was $50,000. He remembered her saying it, not the amount. This time he said 15,000. He didn't correct himself. There was another comment. Oh, the last couple of times when he talked about that comment and he said he was chilled and everything, he said he went back and talked to a colleague in the department about whether he should report to the police. And they agreed that since she was talking about something her brother had said many months before and nothing had happened, that there was no need to go report it. He didn't say that this time. So, all memories over time sort of fade a little, and you've got to be reminded of them. Now, not like Wendy, because Wendy every single time can't remember the same things.
Yeah.
It's as though, the world is created each time she gets on the stand. And this time, I really like Georgia, who went after her each time and made her read it from, one of the emails or one of the texts, and didn't let her get away with any of those statements this time. But if I had time, I'd go back and watch her the last couple of times to see how many times it's the same question that each time she says she can't remember.
Mm-hmm. Yeah, it's going to make for some more great shorts, the little short snippet videos where we can highlight all her stories.
Except I cannot believe if she's prosecuted this, she'll take the stand. That would surprise me a lot. Not impossible, but that would surprise me.
Yeah. Okay. Do you think they're stalling on arresting Wendy because of the effect of losing a mother on the boy's mental health?
No. I think it concerns them. I heard Georgia say that she worries about it, but you can't, if you've got enough evidence that you think that you can convict beyond a reasonable doubt, particularly for a serious crime, I think a prosecutor is ethically obliged to do it. Because this, if you think about this a little, if you shouldn't arrest someone who's a mother, who has children, who's committed a murder, then you're giving a pass to mothers. If you don't arrest someone who's older, who's committed a murder because that person is old, you're giving a pass to, old people. Now, if the legislature wants to say murder is the intentional taking the life of another, okay, except if the person who does it is a mother, or except if the person who does it is over 60, assuming that would be constitutional, then go ahead and do it. But you cannot imagine any legislature on the face of the earth saying that. The crime is the crime, and the person who did it should be held responsible for it. I have no question about it. And the fact it's going to may have an impact on children is terrible, but this murder also has had and will have a lasting effect on Dan Markel's children too.
Mm-hmm. Okay.
I'm lecturing too much tonight.
No. People have more questions, and I feel like we could have wind this down. Me on
my soapbox, and I think it's offensive to do that.
No. We like you on the soapbox. Keep talking if you feel. Are you okay? I'm drinking water.
But I'm a little unhappy that I'm doing this because
No. We want you to keep talking. They don't want to hear from me. Okay. So, do you think the evidence supports that Jeff was being set up as the fall guy?
I think it certainly looks that way. I certainly think you can look at the evidence and draw that conclusion. Yes.
Yeah.
Because some of the information, are you leaving town? When are you leaving town? What the color of the car was, some of it.
The timing, the first time when he had to get Pepto-Bismol.
That's right. It doesn't make any sense if that weren't the case.
Plus, remember that suspicious, was it a text or email where Wendy told her brother Rob that this was her secret boyfriend, Jeff, and don't tell our parents about it because they don't know about him yet.
Do you understand why that? I mean, I like people to act rationally, even if they're crazy, or even if they're evil. I don't understand how that moved anything. Do you see how that connects to anything?
Oh, well, from what I heard, then Rob mentioned Jeff immediately when the FBI went to go talk to him.
Okay.
Like, oh, by the way, she just started dating this secret boyfriend, and maybe he had something to do with it.
That's pretty, and that would tie into what she did with her friend. Was it Jane?
Jane,
Who
yeah,
talked about Jeff.
sweet.
She talked about Jeff a couple of days before, and then in the interview, police headquarters, she looks at Jane when she's asked who might have done it. And she says, "Can you think of anybody else?"
Mhm.
Yeah. But boy, that takes quite a bit of devious planning.
Yeah.
That's not first level planning. That's like second or third level.
Yeah, it just seems so evil because she was mentally playing with him and making it seem at times that she wanted a future with him and telling the kids to call him dad or daddy and telling him not to, don't buy a house because we might move in together and here's my financial passwords, and making him think they had a future together. Just
very manipulative. Even if she wasn't trying to set him up for murder, that's a very manipulative woman in a relationship.
Yeah. And Dan saw through her.
Yeah.
Yeah. Is this a hate crime? Dan was targeted because he was too religious. I don't think so, because there were just way too many other reasons why they wanted to get rid of him.
Right.
Yeah.
And I don't know that it would have mattered that he was too religious if he was willing to have the kids move to Miami.
Yeah.
Donna would still have ignored him and given them hot dogs made of pork for lunch, but I don't think and it's not doing a hate crime requires a lot of evidence. It has to be really your motive, and you did it with purpose because the person was religious, and they didn't do it with purpose because he was religious. They did it with purpose because they wanted the boys and Wendy to be near them in Miami.
Mm-hmm. Okay, thank you. Okay, maybe one last question and we'll take off now because I'm running out of water and I need to practice violin because I started taking violin.
Wow.
And I haven't practiced at all in the last 2 or 3 weeks because of this trial and work. And
you should be able to watch the trial and play the violin at the same time.
No, I couldn't do that all. Plus be in Tallahassee, plus take care of my clients and family matters. So that's why I have to leave because of violin tonight. Plus work. But okay, so Wendy lied on the stand. Can they get her for perjury? Tim Jansen keeps saying no. Nobody
you can, but it's a very difficult prosecution. Usually the way the statutes read is you have to lie under oath twice. That, perjury isn't lying. It has to be under oath. And for perjury to be perjury, usually you need to match up 2 statements under oath. The statute doesn't have to be written that way, but usually they are. And then if you remember Wendy's testimony, it's always, I can't remember. It reads this way. It could be, that sounds right. She never makes or rarely makes direct affirmative statements. So before you can even get to, did she intentionally say something that's not true, you have to first get to, did she say something that's not true? And all her qualifiers make that hard. Then you would have to show that she did it with the intent to do it. And then, as they say, under a lot of statutes, you'd have to show that she did that twice in order to successfully convict for perjury. So perjury prosecutions are not common.
Mm-hmm. Yeah, because she could always just say, well, I just misremembered. I was just guessing. See, I said I wasn't really sure.
Exactly.
Remember, it was so long ago.
Yeah. You're going to do another comedy routine? I can see it coming.
Of course, thank you.
I can see that.
I do feel better that someone, a highly esteemed law professor, actually enjoys the comedy. because there have been lots of negative comments and people saying I shouldn't be doing it and stuff. But Mona and I have so much fun doing our improv comedy.
And you are such a great team. You are really, your physical comedy is terrific. And her Yiddish comments thrown in with that tone, I just think
Yeah.
together you're hilarious.
Oh, well, I'm cavelling with pride that you actually like our comedy and
I
you
do.
watch it.
I
and laugh
do.
and stuff. Have you ever done comedy yourself?
No, I have not.
Oh, okay. Do you want to be in a skit with us?
I don't think I'm
Nope.
enough of a, I mean, I can talk like crazy and make sound silly. I'm not sure that I could be very funny actually acting in something.
Oh, okay. Well, we might just do one more or something, but the next one involves some props or costumes and stuff. So Mona actually ordered something for me. So we can't do our improv until my prop / thing that she bought me shows up in the mail. So, hey, there's Mona. Thank you, Mona. She likes us. She really likes us. Okay, Professor Joe should ask the Donna's questions. Oh, well, you can be in the chat and ask us questions because
I'll
that's
do
part
that.
of the shtick.
I'll do that.
Yeah, is that we address the commenters and make fun of people. And when Patty N showed up in the chat, we had a great time making fun of Patty. Yeah, thank you. Thank you, guys. Yeah. So any last words you want to say to the fine people out there?
No, I don't have anything. I guess I would just say I hope that Wendy is indicted soon. I think I said, did I say it here? I think I'm going to do a channel, and I would
Yes.
really enjoy, certainly continuing to appear on yours, Judy, but also have more time to sort of cover these things and talk about them. So.
Sure. People love hearing from you. Do you know what you're planning to call the channel?
No, I've played with a lot of names and I will finally pick one.
Yeah.
But I haven't yet, no.
Oh, okay. Well, if you need any tips or something.
I
feel
need
free
1,000
to
tips.
ask me.
So.
Yeah, because I've given tips to other people who
There
have
you go.
way past me in YouTube, like SDS and to John and Carl and Brother Council.
Oh, there you
like a
go.
lot.
Then I'm going to be looking for tips from you.
Yeah,
Absolutely.
because I'm good at critiquing people, even though I know my own channel is kind of lacking. Like my friend said, your lighting needs to be better, but I don't know what else to do except buy another box light thing, but it's very crowded in here. So I'm just like, whatever. I don't even know what else to cover at this point. So we'll see what happens.
Yeah, it'll be interesting to do. One thing that the Adelson, the Dan Markel trials have done is, I mean, they've taken a long time, clearly, and it's been quite I know it's been just horrible for the Markel family, I know, and it's been a real drain on resources for the prosecutor's office and, all of that. But it certainly has given us as viewers a number of trials to watch and really a close familiarity with the facts that you would never get in one trial. I mean, we know you can go back, and Judy, you're terrific at it, but you can go back and remember what was said in earlier trials in a way that you can't really do it. Oh, I'm getting ideas for
your title.
Send me all the titles.
I like this one. I like this. Bring in the jury with Professor Joe. Yeah.
Wouldn't that limit me to just doing trial commentary?
And also, this is why I don't really do live commentary, because you can get into trouble with copyright and get your live stream shut down.
You mean by pulling up something without, yeah. Aren't you allowed to do a short piece without being under?
YouTube has its own rules.
Okay.
So
I don't know any of that.
Outside of regular copyright rules, YouTube has their own rules. So, for example, I got somebody's YouTube video taken down because they had used a photo that I had taken of Robert Kwan, who's a friend of mine.
I know, I've seen some of
murder victim. And so, of course, some of those channel supporters wrote me some nasty messages because they were mad that I got the video taken down.
Yeah.
But whatever, this person was totally ripping off the
Yeah.
Peacock TV documentary,
Yeah.
which I was also involved in. So I'm sure NBC would have made a claim if they had heard about it. So
Yeah, I will need to find out those rules clearly, but I do like to look at the actual, the words. And I am more comfortable when I'm doing it to have everybody be able to see and hear it rather than it get filtered, through me as to what I think was said. But we'll see. We'll see.
Yeah. Okay. Well, thank you so much. We'll definitely be in touch.
Yes.
And I do want to give you something because you've
No.
spent
If you help me with the rules and things, that would be much more than anything you can give me. Believe
Okay,
me.
well, I mean, it's just trial and error because I had a live stream shut down back during Katie Magbanua's trial when I was like, well, all these other YouTubers are doing commentary.
Uh-huh.
So I decided to
Yeah,
do
see,
it too.
I'm very happy to have you do all the error, and
Yeah,
then you can just
and I'll
try.
tell you,
So
everything
I
I
want to
did
build on your
wrong.
trial and
Yeah.
error.
Yeah, that's true. Well, thank you. Oh, somebody called me illegal focus. Okay. I don't know who that could have been, but yeah. Thank you. Thank you guys so much for still caring about justice for Dan. And I was going to say that this is just kind of like a testimony as to how Dan Markel continues teaching people.
Yes.
Because I feel like I've learned so much more about criminal law and procedure because of Dan Markel's case.
Yes.
So even though it's such a sad situation, it's resulted in some positive things.
I agree with you. And I've seen a lot more of law in action, certainly than in a classroom or reading cases, and even when I prosecuted, because there's so many more issues that have come up. And it's great, because I think anytime you have a chance to learn something, it's a great day.
Yeah. Yeah, that's right. Okay. Well, have a good night, everybody. Thanks for being here.
Thanks for having me, Judy.
Yeah,
Thank you,
thank you
everybody.
so much. We'll
and
be on.
Send names to Judy. I'll consider them all.
Yes. I'm sure it's going to be a great channel. So.
All right, I'll see you.
Thank you.